Thank you for tuning in to the Financial Investigation Agency's webinar on AML, CFT, CPF for legal practitioners and accountants. Now, today's webinar has been designed to focus on anti-money laundering and countering the financing of terrorism and proliferation, specifically for legal practitioners and accountants. With me today is Joy Brown Unchikwa, who is the compliance examiner, and Farrell George, who is a senior compliance examiner. And I am Timoji Hughes, the outreach officer for the agency. Today we'll be focusing mainly on the legislative requirements each entity in these sectors are required to meet and provide details on what you can do to meet these requirements to ensure your business is in compliance. So without further delay, I will ask Ms. Onchigwa to take us into the presentation.
Good day again to everyone. So before we can begin by understanding what is anti-money laundering and countering the financing of terrorism and proliferation, we must first try to understand what is money laundering, terrorist financing, and proliferation financing. We have already covered these in our past webinars that we've been having, but for the purpose of this presentation here today, we'll just go through the basics of these. So what is money laundering? Money laundering is the act of concealing, retaining, converting, transferring, or in any other way moving funds acquired directly or indirectly from an unlawful activity or otherwise from an unlawful source. Money laundering is effectively the process of integrating the illegal proceeds of crime, and this can be from any crime, into the legitimate financial system by hiding or concealing its true origin. Basically, criminals want to hide the fact that their money came from illegal activity in order to get their money into the financial system. And if there are no criminals, they may even try to hide the fact that the money is theirs. So there are three stages in the money laundering process, which are placement, where the money is entered into the financial system; layering, this is where the illegal funds are disguised by using various layering techniques, such as different transactions or even shell companies, with the intent to hide who the ultimate beneficial owner is; and integration, where the monies are now cleaned and are reintroduced into the economy to be used as legitimate funds. So terrorist financing is the provision or use of funds for the purpose of terrorism, or the acquisition, possession, concealment, conversion, or transfer of funds that are directly or indirectly intended to be provided or used for the purpose of terrorism. In essence, terrorist financing is the use of funds or the making available of funds for the purpose of terrorist activity. It can include the giving of any type of assistance to help further sponsor, promote, or facilitate terrorism or terrorist activity, from providing funds to buying weapons, providing training or assistance to shelter, or buy clothing or transportation for terrorists, or even facilitating so that terrorists can broadcast or hand out leaflets to promote their terrorist ideologies. A key point here to note is the difference between money laundering and terrorist financing. With money laundering, the funds originate from criminal sources. However, with terrorist financing, it can be from both criminal and legitimate sources. With terrorist financing, it is not necessarily about where the money came from, but more about where the money is going and hiding the purpose for which it is intended to be used. Another way of looking at it are the stages in which terrorism is funded. The first is the raising of funds. This can be through the use of charities, legitimate businesses, self-funding, illegal activities, and so on. Then there is the transferring of funds to wherever the intended terrorist activity is likely to be. And lastly, there is the using of funds. For example, funds may be used for purchasing weapons or to provide training and housing for persons who are a part of the terrorist organization. So what is proliferation financing? It is the manufacture, acquisition, possession, development, export, transshipment, brokering, transport, transfer, stockpiling, or use of nuclear, chemical, or biological weapons and their means of delivery and related materials in contravention of national laws or international obligations. With proliferation financing, criminals intend to use the funds to acquire goods that can contribute to the development of weapons of mass destruction programs without being caught. There are also 3 stages in relation to proliferation financing, which include the raising of funds. Just like terrorist financing, this can occur by both legitimate and illegitimate sources. Disguising the funds are transferred into the international financial system and the procurement of materials and technology. With this stage, the funds that were placed into the international financial system are now used to pay for things like materials, technology, and logistics needed to create these weapons of mass destruction. So now that we have looked briefly at the definitions of money laundering, terrorist financing, and proliferation financing, we will now look at what is referred to as the anti-money laundering and financing of terrorism and proliferation regime. Because of financial crimes such as money laundering, terrorist financing, and proliferation financing, countries have been required to implement an anti-money laundering and countering the financing of terrorism and proliferation regime. The purpose of this regime is to allow countries and those sectors most vulnerable to be at risk for abuse to be able to establish and implement policies, processes, and procedures to forestall and combat these financial crimes. The BVI has put in place a legislative framework to fight money laundering, terrorist financing, and proliferation financing that has incorporated and adopted international standards and recommendations. This legislative framework includes legislations and guidelines for all DNFBPs. It also includes the establishment of supervisory bodies to monitor and ensure that these laws and standards are adhered to. Let's now look at some of the key legislations that relate to the AML, CFT, CPF regime. Some of the applicable legislation include the Proceeds of Criminal Conduct Act 1997, the Anti-Money Laundering Terrorist Financing Code of Practice 2008, the Anti-Money Laundering Regulations 2008, and the Financial Investigation Agency Act 2003. Some more of these legislation can also be seen here on the slide as well. So these legislations are crucial tools that provide guidance to assist all supervised entities with establishing internal controls to combat money laundering, terrorist financing, and proliferation financing, and are also mandatory for all DNFBPs to follow and comply with. So let's take a look now at the supervisory bodies. In the BVI, there are 2 agencies that are responsible for supervising businesses for money laundering, terrorist financing, and proliferation financing purposes. The Financial Services Commission, who supervises and monitors financial institutions such as banks, trust and corporate service providers, and money services businesses. The other is the Financial Investigation Agency, who supervises and monitors DNFBPs such as real estate agents, lawyers, accountants, high-value good dealers, as well as nonprofit organizations. As our focus today is on legal practitioners and accountants, which are considered DNFBPs, it should be noted that persons in these sectors are supervised by the Financial Investigation Agency, specifically the Supervision and Enforcement Unit of the agency. The Supervision and Enforcement Unit is responsible for registration, supervision, and compliance. However, there is another section of the agency, which is the FIU, and that area is where all the suspicious activity reports are sent to be analyzed and disseminated. So now that we have discussed the purpose of the AML, CFT, CPF regime, and the bodies in charge of ensuring that these regimes are followed, let's look at how it applies to legal practitioners and accountants. So to take us into the next section, I will pass the presentation on to Mrs. George.
Thank you very much. Good day, everyone. So as it relates to legal practitioners and accountants operating within the Virgin Islands, the AML regulations outline the business of undertaking relevant business. And this relevant business is what is applicable to legal practitioners and accountants, especially as it relates to their obligations for anti-money laundering and countering the financing of terrorism and proliferation. So If you are a legal practitioner or an accountant undertaking relevant business, so this is the provision of services to clients which involve transactions concerning any of the activities which are outlined on the slide, then you fall within the supervisory regime, and you and your firm are required to follow the AML, CFT, and CPF suite of legislations that are applicable. So just to clarify here, if you are undertaking any of these types of works, so the definition does not solely apply to undertaking the transactional work directly. If your firm is involved in the transaction in any way, shape, or form, and this includes providing advice on the transaction, then you are providing relevant business. So the definition is quite wide, and please be aware of that. Also, before we move on, it is also worth clarifying here, it does not matter the size of your business or the size of your firm, whether you are a sole practitioner or a large firm. If you are undertaking relevant business, so if you fall within that definition, that's the type of work you are doing, you fall within the registration and supervision of the agency, and you are required to undertake AML, CFT, and CPF provisions. So, why is AML, CFT, and CPF relevant and important to legal practitioners and accountants? Well, these professions are often the first professionals consulted by businesses and individuals when seeking general business advice on a wide range of regulatory and compliance issues. And for this reason, the Financial Action Task Force have stated that they are vulnerable and at risk of potential abuse from money laundering, terrorist financing, or proliferation financing. Legal practitioners and accountants are seen as the gatekeepers because they literally protect the gates of the financial system through which potential users must pass in order to succeed. Gatekeepers have the ability to allow or disallow illicit funds excuse me, into the financial system, whether knowingly or not. Because both legal practitioners and accountants are capable of providing financial expertise to launderers or terrorist or proliferation financiers, their role in AML, CFT, and CPF is critical. For example, accounting expertise may be needed to set up complex illicit transactions and to unravel them, especially where organized crime is involved. Similarly, a legal practitioner's skills and knowledge are important in creating legal structures that could be used to launder money or finance terrorism, for the ability to manage and perform transactions efficiently and to avoid detection. As such, legal practitioners and accountants must see AML, CFT, CPF policies and procedures as a critical part of their operational practice. This is important because the consequences of participating, whether knowingly or unknowingly, in money laundering, terrorist financing, and proliferation financing activities, or failing to prevent one's practice from being abused from the same, can be catastrophic, not only to you and your firm, but also to the reputation of the Virgin Islands. So, moving now into the actual obligations for legal practitioners and accountants as it relates to what is applicable in the code. So, in the BVI, in accordance with the AML Code of Practice and the AML regulations, legal practitioners and accountants are required to establish and maintain a written and an effective system of internal controls, which must include policies, processes, and procedures that focus on money laundering, terrorist financing, and proliferation financing prevention. They are required to conduct institutional as well as customer risk assessments. They are required to undertake an appropriate level of due diligence on the transactions that they are entering into. They are required to appoint a money laundering reporting officer. They are also required to report any suspicious activity or any suspicious transactions or attempted transactions they may come across in the course of their business. And they must maintain accurate records as well as provide appropriate staff training on relevant AML, CFT, CPF matters to all members of staff within their firms in order to ensure that the firm is adequately protected. So for the remainder of the presentation, we will look at these obligations in a bit more detail and see how they can be further applied to firms operating within this sphere. Looking at now the establishment of written internal controls. So Section 11 of the AML Code is the overarching section, which requires an entity or a professional, so in this case a legal practitioner firm or an accountancy practice, to establish and maintain a written and effective system of internal controls. So these internal controls are your policies, your processes, and your procedures that your firm must implement in order to forestall and prevent any potential risk of money laundering, terrorist and proliferation financing, or any other type of financial crime occurring from within or for their business to be used for this purpose. We will often refer to these internal controls as your firm's compliance manual. And the purpose of these internal controls is for your firm to effectively identify, assess, and understand any risk to which your firm is exposed to, for you to be able to have procedures in place to manage and mitigate any risk the business then identifies, as well as any risk identified by competent authorities or supervisory bodies such as the agency. We would also like to take a moment to note here that as part of establishment of internal controls, your firm should ensure that it familiarizes itself with the Virgin Islands National Risk Assessment, as well as sectoral risk assessments that are issued by the Financial Investigation Agency, as well as by the Financial Services Commission. These documents can be found on the agency's website and should form part of your firm's critical internal control system. And another reason why establishing written and effective internal controls is important is that it allows your firm to be able to apply enhanced measures where it is required to manage and mitigate a higher risk from a situation or a transaction or from any particular client that you may be dealing with. So, what should your business's internal controls include in more detail? Well, they should focus on the operations of the firm and include what sort of products and services the firm offers, what transactions the firm engages in, what sort of customers you have, where your customers are from, as well as what countries are the transactions being carried out in or from. The internal controls should include the firm's policies, processes, and procedures for conducting both an institutional risk assessment as well as a customer risk assessment. They should have details on the person designated, so your MLRO, by the business to carry out the AML, CFT, and CPF requirements. They should outline any other measures that business has for maintaining records, as well as for ensuring that staff is appropriately trained. And they should also have policies and procedures for conducting customer due diligence and outline any additional controls that the firm has as it relates to higher risk customers or transactions or products and services offered. So these are just a few of the requirements for your internal controls. we would ask that you review section 11 of the AML code in its entirety to ensure that you are aware of your firm's obligations. Now, let's look at some more of these in a bit more detail. So, you will have heard us mention risk assessments a number of times already. As a legal practitioner and accountant firm, when seeking to conduct transactions, your firm must first assess its risk exposure to money laundering, terrorist financing, or proliferation financing. This is done by examining your firm's activities, objectives, services, customers, and transactions, and then considering what level of money laundering, terrorist, or proliferation financing risk each category may pose to the business. Section 12 of the AML code requires a legal practitioner firm and an accountancy practice to carry out institutional risk assessments as well as customer risk assessments. An institutional risk assessment is an assessment of the overall business of the entity, which includes an assessment of all relevant factors, such as the business's customers, products, services, as we've already mentioned. We do have a separate webinar, which was on institutional risk assessments alone, which the agency held a couple of weeks back. It is available on our website for you to review, and we would highly recommend that you take the time to review that webinar, as institutional risk assessments is something that every firm is required to undertake and document. And it may be that the agency at some point asks to see a copy of your firm's institutional risk assessment. So, looking at now at client or applicant for business risk assessments. So this is, as the name suggests, an assessment of each applicant for business, each client that your firm deals with or provides services to, including the ultimate beneficial owners. The purpose of this type of risk assessment is to determine the existence of any risk that that client poses, to determine how best to manage and mitigate the risk identified, to develop, establish, and maintain appropriate systems and controls to respond to those identified risks, and to ensure that your firm is in full compliance with the requirements outlined in the AML, CFT, and CPF legislations. So, in addition to undertaking those risk assessments, the AML code requires that legal practitioners and accountants document and maintain a record of each of these assessments. You should ensure that all relevant risk factors are considered before determining what level of risk the institution faces or the customer poses to your firm. So, looking further at conducting a risk assessment, the chart provided shows a few examples of the types of questions your firm may ask in determining the level of risk for various aspects of the business, for various customers. So this is not an exhaustive list, but the purpose of this chart is to give you an idea of the types of questions that you should have in mind when undertaking your customer risk assessment. Looking at these now, so you may wish to look at what type of client are you dealing with. So is it an individual? Is it a company? Is it somebody who is considered high risk, low risk, etc.? What type of transactions is the customer performing? Do those transactions involve multiple persons or multiple jurisdictions? In relation to the transactions, what is the volume and what is the size of these transactions? Are the countries the business transactions coming from or going to considered high risk or subject to any types of sanctions or embargoes? And does the business relationship involve intermediaries or third-party clients? And if it does, are you still able to identify who the ultimate client is and who the ultimate beneficial owner is of the transaction that you are becoming involved in? Performing a risk assessment is crucial because without this step, the business would not be in a position to identify its most vulnerable areas as it relates to money laundering and terrorism and proliferation financing. And it would therefore be unable to determine the level of risk its products and services and its clients may bring to the business. So conducting a risk assessment on your firm, as well as on your firm's clients and customers, is critical and should not be a step that is neglected when establishing your internal controls. Moving on now to the requirement to appoint a money laundering reporting officer. Section 16 of the AML Code requires all legal practitioner firms, as well as all accountancy practices, to appoint a money laundering reporting officer. This person should be somebody who has sufficient seniority within the business in accordance with Section 13 of the AML regulations, and should also meet the requirements set out within Section 13 of the AML regulations. So some of these are that they must have a clear understanding of the activities of the business as well as its clients. It really should be somebody who knows your business. It knows your firm's ins and outs. It should be somebody who has appropriate qualifications as it relates to AML CFT, as well as a working knowledge of the BVI's AML CFT legislations. You should also be mindful to appoint somebody who is independent. So we understand that it may not always be appropriate or applicable to appoint an individual solely to be the firm's MLRO. However, you should try to appoint somebody or make provisions for whoever the firm's MLRO is, that they have the adequate resources and time necessary to carry out this critical function properly. And last but not least, your MLRO should be able to communicate and report to your firm's management, to your firm's board of directors freely. So there should be no restrictions on them being able to contact management as well as the financial investigation agency without having to first seek consent from the board. I will now pass you back on to Ms. Brown to take you through the remaining requirements.
Thank you. So we will now look at another key obligation which is essential to a good AML CFT CPF regime, that is conducting customer due diligence. Customer due diligence is a process of getting to know your customer. This is done by collecting all relevant data and information that can be used to aid your business in getting to know the person or persons you are entering into a business relationship or one-off transaction with. Section 19 of the AML Code requires an entity or professional to conduct customer due diligence when establishing a business relationship, when effecting a one-off transaction, when there is a suspicion of money laundering, terrorist financing, or proliferation financing, when a business or transaction presents a high risk, and when a business may have doubts concerning the veracity or adequacy of information received from an applicant for business or customer. So what is required when seeking to conduct customer due diligence? A business must inquire and identify the applicant for business or intended customer and verify their identity, obtain information on the purpose and intended nature of the business relationship, use reliable evidence through inquiries as necessary to verify the identity of the applicant for business or customer, utilize measures to obtain information on the applicant for business or customer source of wealth and funds, size of business, and nature of transaction. Conduct ongoing monitoring on business relationships and transactions undertaken, and identify and verify the identity of a person acting or who purports to act on behalf of an applicant for business or customer. So now that we have looked at what information is required to be collected as part of the CDD process, we will now examine in more detail the various types of customer due diligence a business would be required to perform. So the AML code requires 3 types of due diligence a business should carry out. These are simplified due diligence, standard customer due diligence, and enhanced due diligence. Simplified due diligence is the lowest level of customer due diligence that can be conducted on an applicant for business or professional that poses a low risk of money laundering, terrorist financing, or proliferation financing. In simplified due diligence, the applicant for business or customer poses a lower level of risk than standard due diligence and far lesser risk than customers in the enhanced due diligence category. With simplified due diligence, the code makes mention of instances where a business might consider an applicant for business or customer to be of low risk. Some of these instances include if the person has a source of fixed income, publicly listed companies subject to regulatory disclosure requirements, or government statutory bodies. In carrying out standard customer due diligence, a business must identify the applicant for business or customer. This entails gathering and recording information about the applicant for business or customer to establish who the applicant for business or customer is. Information that must be gathered and recorded may differ based on whether the customer is an individual, legal person, or a legal arrangement. Verifying the applicant for business or customer's identity. This entails gathering evidence via reliable and independent information, data, and/or documentation to confirm that the customer is who he or she say they are and authenticate that the identification information provided is true and accurate. Obtaining details of the purpose of or intended nature of the business relationship or transactions. This requires an entity or professional to establish the reason why a customer is seeking to establish a business relationship or conduct a one-off transaction. Understanding the applicant for business or customer and their circumstances. In understanding the applicant for business or customer and their circumstances, information that should be collected would include the nature and details of the person, occupation, or employment, the nature or details of their business activities, assets held or managed or to be held or managed, the anticipated level and nature of activity to be undertaken throughout the business relationship, the applicant for business or customer's source of funds or wealth, the countries with which they intend to engage or have connections with, whether the applicant for business or customer has any criminal record or is a known associate of criminals or criminal organizations, and whether the applicant for business or customer is a PEP, among other things. For enhanced due diligence, this is to be performed on an applicant for business, customer, or transaction that presents a higher than normal risk. For these situations, along with collecting a normal customer due diligence information, an entity or professional is required to obtain additional information on the applicant for business or customer undertaking, which includes undertaking further research where necessary, obtaining additional information on the source of funds or wealth of the applicant for business or customer, and verify this information along with obtaining the approval of senior management to commence or continue the business relationship, among other things mentioned in the code. So another key requirement outlined in the AML code is a requirement to report a suspicion. Section 18 of the code mentions that an employee is required to report a suspicious activity or transaction to the money laundering reporting officer. This should be in a form established by the business as part of its internal controls, or as the commission or the agency may approve in writing, provided that the report complies with the requirements outlined in Section 55 of the code. This report should provide details of the information giving rise to any knowledge or reasonable grounds for the suspicion held including the full details of the customer, such as their name, date of birth, or date of incorporation or formation if it is a company, as well as the address. Section 18 also requires a report to be made on any attempted activity or transaction that the business has turned away regardless of the amount of the transaction. A suspicious transaction report should also be made where an applicant for business or customer fails to provide adequate information or supporting evidence to verify his or her identity, or in the case of a legal person, the identity of any of its beneficial owners. The reporting officer also has an obligation under this section of the legislation. They must, upon receipt of a report concerning a suspicious activity or transaction, investigate the details of this report and determine whether or not to file an external SVR with the agency. It should further be noted that where the reporting officer makes a determination not to file a report with the agency, this should be documented in the manner outlined in this section and be kept as part of their record-keeping requirements. So the agency has issued additional guidance on reporting suspicious activities, which can be found on our website. So we would encourage you to take a look at this information. Now we will go into the record-keeping requirements. Section 42 to 45 of the AML Code outline what records a business would be required to keep, as well as the manner and form in which such records should be kept. It mentions that records should be easily retrievable, and this can be kept in the, digitally or electronically once it is made easily available to the agency or any other supervisory body promptly upon request. Records should also be kept for a minimum of 5 years. However, there are instances where a business might be required to keep records for a longer period of time. An example of this is if a specific transaction or person is under investigation by the agency or any other supervisory body. The code also mentions the types of records that are required to be kept, some of which include a record of the business's policies, processes, and procedures as it relates to the AML code, and also additional information can be found in the AML regulations. Section 47 and 48 outline the training requirements for staff. Training is a very important factor in combating money laundering, terrorist financing, and proliferation financing within a business. For example, if employees are not sufficiently trained, they will not be able to forestall or detect any money laundering, terrorist financing, or proliferation financing red flags, which would prompt them to file a suspicious activity or transaction report, or know what customers, products, or services create a money laundering, terrorist financing, or proliferation financing risk to the business. For these reasons, the code requires that each employee of the business, including the directors, senior officers, key staff, other staff, which include temporary or contractual employees, be trained according to the appropriateness and level required by the AML regulations. For example, the MLRO would require specialized training as opposed to those persons that are considered to be key staff. And in contrast, key staff will require more in-depth training than other employees that are not engaged in the day-to-day activities or transactions. Training should also be tailored to the employee's responsibility and be conducted at the appropriate level of detail. In addition to providing training, it is the responsibility of each business to have systems and procedures in place to test employees' understanding of the training given. So we would urge you to not just issue training, but you should also have a mechanism in place in order to test the employees' understanding of this training, as this will help gauge the effectiveness of the training and would ensure better compliance from employees. The code further requires that training be conducted frequently and at a minimum of at least once a year. So to summarize, I will now pass the presentation back to Mrs. George.
Thank you. So we're mindful that we have covered a significant amount of topics today, and it may seem daunting in terms of the requirements that are applicable to your firm. We would like to take the opportunity to mention that there are various resources available to assist legal practitioner firms and accountancy practices to better understand their AML, CFT, and CPF obligations, and how to implement measures and policies required under the law to ensure that your firm stays compliant. So this does include all of the legislations mentioned in the presentation, as well as other documents. There is a significant amount of guidance available on the agency's website under the tab Supervised Entities, and we would really encourage you to take your opportunity to have a look at those pages. It includes guidance notes on AML, CFT for the legal practitioner and accountancy sectors separately, and it also includes webinars on these various topics, including money laundering, terrorist financing, as well as proliferation financing. And as well as yourselves, we would ask that you encourage all your staff to view these webinars and these training sessions, which the agency has put together for the benefit of your firms. At this point, it is also worth noting that as part of its supervisory and compliance monitoring work, the agency undertakes inspections and examinations of your firms. So at some point, your firm will be contacted by the agency, and we may ask at that point to see your compliance manual to ensure that you have policies and procedures in place that are in accordance with the law. We may also notify you that we have chosen your firm to undertake an inspection, and at that point we will tell you what topic that inspection relates to. So it is worth noting that at some point or another, all firms and practices will get engagement from the agency. Having said that, we do strive to work with supervised entities, so legal practitioners and accountants, to ensure that they understand the risks they face, as well as the obligations and measures they are expected to implement. We are not able to specifically tell you or your business what to do in order to meet those requirements, but we are able to provide you with support and guidance as to where you can find information on your obligations. Within the agency, each entity, each firm is allocated a compliance examiner. And if you do not yet know the name of your firm's examiner, please contact the unit and we will ensure that you receive this information. With that being said, we are now at the end of our webinar, and we would now answer the floor to any questions that you may have that you can pose to us using the questions facility that is provided within this program.
Thank you, Ms. Brown and Mr. George. We do have a question coming in. It says, if I am a sole proprietor, it's just me doing legal work, these obligations seem like a lot for me and my small business. Why do I have to do this?
Okay, thank you for that question. That is actually a really good question. So we understand that these obligations may seem like a lot, especially if you are a small practice or a sole practitioner firm. However, if you are undertaking the business of relevant business, so if you are undertaking any of those services that was outlined in that slide, you are covered under the regime. It also means that, unfortunately, those practices and those types of services provided are more susceptible to abuse from money laundering, terrorist financing, and proliferation financing. For this reason, the legislations apply to you in full, and I'm afraid there can be no exceptions to that. So you are required to meet those. However, what I will say is that the agency has provided a significant amount of guidance in order to aid you.
Okay, another question. Where a potential customer or applicant for business declines to provide any ID, DOB, or any other identifying information, is that sufficient to warrant a SAR?
Okay, that's another excellent question. That's really up. Your firm needs. You need to decide that, and your firm needs to decide that. So, if again, the suspicion, the decision as to whether a SAR should be filed with the agency rests with the firm's MLRO. So this is why we say that the MLROs must have a minimum requirement of qualifications and experience, because the firm and the MLRO need to look at that situation and make a determination as to why is the customer refusing to provide basic information that is actually required under the law. So basic identification information, date of birth, or any other verification information. And do you consider that to be suspicious? Because in all actuality, those are things that customers should be able to provide you in order to verify doing that. So is your firm able to really understand who you are dealing with? So that you really need to understand that. So is that suspicious to you? Because that is a normal thing to be able to provide. And if you consider that suspicious, then you have to file a SAR. The other thing that I would say is, and Ms. Brown covered this in her slide, was that what is the reason for them to do this? So although it's sufficient, is that a sufficient enough reason to do that? Or is that something that you consider to be out of the ordinary? And then to finish that off, are you going to continue to act for that client? Because the requirement to meet, to get those are within the code. So that is something that you also have to consider.
Okay.
It looks like we just have a last minute question that's come in. And that's actually based on institutional risk assessments. So it would appear that the interpretation of the AML code is geared towards big firms, particularly as it regards to institutional risk assessments. So bear with us while we read the rest of the question. For example, a small firm providing services to locals with little to no interaction with foreign nationals, how are they to assess their risk? Well, actually, the requirement within the AML code is institutional as in firm risk assessment. So it isn't geared towards big firms, it's geared towards all firms. So as a firm, if your firm is really only dealing with clients within the BVI and not necessarily international clients, you still have to do a risk assessment of that, because you still have to look at who your client is. You have to look at the types of services that you're providing, as well as the types of transactions you are entering into. So the institutional risk assessment takes into consideration a lot more factors than just where your client is coming from, and it's really applicable to the risk. It is a wide variety of risks. So what I would really suggest is our webinar or institutional risk assessments is available on our website, and I would really recommend having a look at that. And if you have any follow-up questions, feel free to contact the supervision unit. We have a question coming in relation to MLROs, which is, are sole practitioners expected to employ MLROs? So the requirement is, so let's just be very clear in terms of the wording. All firms, if you are a DNFPP business, if you are a legal practitioner, or an accountancy firm undertaking relevant business, you are required to appoint a money laundering reporting officer within your business. That money laundering reporting officer, if you are a sole practitioner, can be yourself, or it could be another external individual. What I would say is have a look at the requirements of the AML code and the AML regulations, because it does give you a bit more information as to who can be your firm's MLRO and who you can appoint. But the requirement is there. You must appoint a money laundering reporting officer. It's a legal requirement, and there are no exceptions to it, regardless of the size of your practice. Okay, so we have a follow-up question to the risk assessment question, which is, For example, if your customer is a local lawyer who practices criminal law, are we to assess them as high risk as a general principle? So I think this is quite a high question. This is quite a wide question. And as we've mentioned within the context of this webinar, risk is more than just one factor. So this is not a question for us to answer. This will be a question for you to answer, because the context of getting risk going is more than just one factor. So you really have to look at risk in the wider context. Again, types of service that you're providing, where the customer is from, what kind of transaction is being entered into, are they a PEP? Are they associated with a PEP, etc.? So there's a lot more to risk than just one factor. We have a comment in relation to the relevant business. So it says, the categories under relevant business are quite broad. Can the unit undertake training on this as the authority for legal practitioners and accountants to ensure relevant persons are actually classifying transactions as relevant business or not? I think that's a fair question. The agency has issued guidance and further clarification in relation to this. So if you have a look on our website, and if you have a look at the AML CFT guidance notes that have been issued for legal practitioners and accountants, there is an explanation provided on relevant business. However, it is a fair point, and it is something that we are considering issuing further specific guidance on as to how we explain that further.
I want to thank you for your questions and for tuning into today's webinar on AML CFT CPF for legal practitioners and accountants for the Financial Investigation Agency. I want to thank you, Ms. Brown and Ms. George, for facilitating this discussion. Thanks for watching.